County News Support is reconvened.
Please be seated. All right, we are on the record in case number 25 TRD 01258, caption the state of Ohio versus Jeremiah Mackey Jr. That's you, sir?
Yes, sir.
All right, so the record should reflect that the defendant is present in the courtroom today. Miss Yeager is here on behalf of the state of Ohio, and this matter is scheduled for a trial to the court. The defendant is charged with 2 counts of involving driver's license violations. One is driving under. It looks like it says security on the citation, but according to the new Albany Municipal Code, it's basically just driving under forfeiture.
What I have is a financial responsibility.
Yeah. So the driving under an OVI charge, or under an OVI suspension charge, is a first-degree misdemeanor. Carries up to 180 days jail, up to a $1,000 fine, and up to a 1-year life.
If you've spent even 5 minutes on Sovereign Citizen TikTok, you've probably seen this play before. I do not consent, maritime law, and a whole bunch of pseudo-legal spaghetti thrown at the wall. But courts? Yeah, they've got industrial strength non-stick.
License suspension does carry mandatory minimum penalties of up to, or of at least $250 fine, a 1-day license suspension, and at least 3 consecutive days in Licking County Jail. The other charge is an unclassified misdemeanor, I believe, is it not?
Yes.
Yeah, so it doesn't carry any potential jail time. And either way, if the defendant were to enter pleas of guilty or be convicted of the offenses, they would merge for the purposes of sentencing. So there'd only be 1 conviction. Ms. Yeager, is the state ready to proceed with trial today?
Yes, Your Honor. However, Mr. Mackey informed us he actually wanted this set for a jury trial, not a bench trial today.
All right. And Mr. Mackey, what do you have to say about that?
She is absolutely correct, Your Honor. Also, I shared with her as well. I have documents, if I could serve the court.
Why don't you just tell me what you have there first?
These documents that I have is referring to a removal that's been passed up from the clerk, and as well my case is in fact on an appeal at the moment.
On appeal.
Notice how the judge explains that the charges merge for sentencing? That's legal speak for you don't get double punishment for overlapping offenses. It's one of those quirks that sounds fair until someone tries to exploit it with fringe legal gymnastics.
Which district?
The 10th district.
Okay, now that covers Franklin County, and we're in the 5th District Court of Appeals.
I'm sorry, it's the 5th district. You're absolutely right. It's the 5th district.
I'm assuming that your appellate paperwork is similar to what you've been submitting to the court. That's what it looks like.
That one, or this?
But just in general, all of your filings with this court are on this. It's kind of a unique. The documents are unique in that they're gray and they're typed in all caps, and one of them, it looks like, from what you just filed this morning, was filed in the United States District Court in the District of New Jersey in the Newark Division, and this is obviously Newark, Ohio. What I construe to be a motion to continue for the purpose of setting the matter for jury trial, because the matter's been pending for quite some time. Let's see, all of February, all of March, and now halfway into April. And so the defendant did have an ample opportunity to submit a demand for trial by jury, but that demand was made in an untimely fashion today. So the record will reflect that the motion was made, but the court denied that. So your options at this point, Mr. Mackey, are to either have a trial. The state has indicated it's prepared to proceed, and you can obviously represent yourself. You have the right to, if you wish, to change your pleas from not guilty to guilty or no contest. But I do not believe the state is inclined to dismiss the charges. Is that correct, Ms. Yeager?
Correct, Your Honor.
All right. So how would you like to proceed? Would you like to have your trial today, or did you want to change your pleas from not guilty to guilty or no contest?
This right here is where courtroom reality checks kick in. You can't walk into court last minute and say, "Surprise, I want a jury." Legal deadlines exist for a reason. Try pulling this move in Monopoly Court, maybe.
Basically, number one, your paperwork from that purports to be from the federal district court doesn't look like pleadings from the federal district court. Those are plain white paper with the case number in blue up at the top of the page, and that's not how yours are captioned. Furthermore, as far as jurisdiction is concerned, this court does have jurisdiction because this is an alleged violation of the traffic laws of the city of New Albany that is alleged to have occurred within Licking County. This court has jurisdiction over traffic offenses that are alleged to have occurred within Licking County. And by being here today and by entering pleas, you've waived any objection to personal jurisdiction over you. All right?
Your Honor, I object on this bench trial. I do want a jury trial.
Okay, and as I've already explained to you, you did not make your demand in a timely fashion, so the motion to continue and the request for a trial by jury is going to be denied. It doesn't sound to me like you don't want to, I know you don't want to change your pleas from not guilty to guilty or no contest, so at this time I'm simply going to order or ask the prosecutor to call their first witness.
Thank you. The state will call Officer Course to the stand, please.
Officer, please come forward and be sworn. Oh, actually, before he does that, Mr. You can have a seat, but Mr. Mackey, you indicated.
I mean, sending Ohio court documents to New Jersey? That's like ordering a pizza in LA and complaining it didn't show up in New York. It's baffling, but also darkly hilarious. What's the wildest legal misstep you've seen? Drop it in the comments.
The court would appoint an attorney to represent you. However, if it's your intention to represent yourself, it is necessary to execute a written waiver of the right to counsel. 1258. So I'm going to have the bailiff hand to you a form entitled attorney waiver. I'm just going to read it into the record in open court for right now. It says, it's captioned attorney waiver, and it says, in open court and on the record, I hereby waive my right to an attorney in this case. I've been fully advised of my right to be represented by an attorney, including my right, if applicable, to have an attorney appointed by the court at no cost if I qualify. I agree to proceed without an attorney at this time. I have been advised of the charges against me and the maximum possible sentence that they carry. I've also been advised if there are any mandatory minimum penalties which might apply. And then it says, in witness whereof I have hereunto subscribed my signature this 11th day of April 2025. So if it is your intention to represent yourself and to waive your right to an attorney, go ahead and sign by the X there, but do please read that because I'm going to make sure that you understand what it is.
Yes, that one.
I've been objecting to this. I object this trial.
I'm sorry, I didn't hear what you said.
Refusing to sign this, Your Honor. At this moment, I'm not refusing to sign it. This court jurisdiction has been divested.
Well, I've already ruled on that, and that can certainly be appealed at a later time. But this part of the case, this portion or this part of the process is going to go forward. If you later appeal, if you're found guilty, I'm not saying you will be, but if there's a conviction that's entered, you have the right to appeal to the 5th District, arguing that this court never had jurisdiction over you, which means basically this would all not count. But you don't get to make, I've already made the determination that the court does have jurisdiction over you. If you don't want to sign that form, obviously I can't make you do that, but I will declare what's called a constructive waiver of counsel. And what that means is you've said out loud that you wish to waive your right to counsel, that you want to represent yourself. I'm going to accept that as a valid waiver of counsel, even if you don't wish to sign that. So, Ms. Kyle, if you'll bring this back to me, and for what it's worth, Mr. Mackey, this was filed with the court, and I do have a copy of that, and I did look at it, okay? All right, very well. Please swear in the witness.
Do you solemnly swear or do you affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I affirm.
Please have a seat, sir. For the record, you're going to give your name and spell your last name.
Officer Michael Cohrs, Cohrs.
And the address of your precinct?
50 Village Hall Road, New Albany, Ohio, 43054.
Thank you, sir.
Thank you. You may inquire.
Officer Course, how long have you been with the New Albany Police Department?
Over 6 years.
And were you so employed on January 29th of 2025?
Yes.
And were you working that day?
Yes.
What shift or hours were you working?
Second shift, it's 2 p.m. to 10 p.m.
And were you wearing a uniform of the day like you are in court?
Yes.
And were you driving a marked cruiser with a working visible light bar?
Yes.
And what were your duties that day?
I was working standard patrol. I would believe I was on zone 3, which is the Licking County side of New Albany.
Is that for like traffic enforcement?
Correct.
And what kind of training have you undergone for traffic enforcement?
I was trained at the Columbus Police Academy over 2 weeks of traffic enforcement to include all traffic laws and proper traffic stops and procedures.
And as of January 29th of 2025, were you up to date on all continuing education, training, and certification requirements?
Yes.
We're going to draw your attention to about 4:50 p.m. Whereabouts were you on patrol at that time?
I was on Beach Road heading southbound just north of State Route 161.
And is that in the city of New Albany in Licking County, Ohio?
Yes.
While on patrol, what first drew your attention to the defendant's vehicle?
As he was traveling northbound, making a left turn onto the State Route 161 westbound on-ramp, I observed he had dark tinted windows, which initially drew my attention. And then as he passed me, I made the right-hand turn, drove behind him, and entered his license plate.
This is what we call the enough is enough moment. The judge just initiated a constructive waiver, basically saying, you've made it clear you want to go it alone, and I'm not going to beg you to lawyer up. Dangerous move, folks. Representing yourself in court isn't brave. It's a fast track to regret.